Welcome to the Good Divorce Show, where we can help you learn how to navigate the journey of divorce with less conflict, less debt, and equip you not to just get divorced, but also learn how to be divorced. Your host, certified divorce coach Karen McNenny, shares her wealth of knowledge, gets advice from other relationship experts, and interviews couples who learn how to have a good divorce, so you can too. Now here's your host, Karen.
Well, hello, listeners. I'm Karen McNenny, your Good Divorce Coach. Thanks for joining me in conversation today. We are chatting with Charles Jamieson, who comes to us from West Palm Beach, Florida, but works with clients throughout the country. He is a lead attorney and consultant to individuals with divorce issues in more than 20 different states. He began his family law practice in Maine, assertively representing clients in divorce cases, but has come to understand what the importance is of a proactive, assertive representation for each of his clients, regardless of their geographic location. He is board certified in marital and family and law, and we are so happy to have you with us today, Charlie. Welcome to the Good Divorce Show.
Karen, thank you very much. It's a pleasure to be here.
Now, for someone who has been working in this industry for more than 40 years, I'm guessing you have some stories to tell and some nuggets of wisdom to share. Let's just start with the basics. As clients are moving to build a relationship with their lawyer, from your standpoint, what are the things that you wish those clients knew before they even walked in the door, and what they sometimes don't understand about the entire divorce journey?
And sometimes their attorneys are not even telling them these things. But generally speaking, I think these are some nuggets that attorneys wish their clients knew before they walk in the door. The first one, maybe even the most important one, is you're probably not going to get your day in court. Now, everyone wants to tell their story about how they've been harmed, what's wrong, why the other side is so bad, why they should be victorious, why the other side should be vanquished forever. And in part, that's what attorneys, people like you, therapists, other divorce coaches have to try to coach them through so they can get them off their chest. But they're eager to tell the judge because they think the judge is going to make it all better. Unfortunately, well, not unfortunately, frankly, fortunately, 90 to 95% of all divorce cases settle for many reasons, but basically because after a while, the parties get smartened up and they understand that it's a financially expensive process. The only people who are making money are the lawyers. Therefore, the more money we keep spending, the less we have to divide. And frankly, they get financially and or emotionally exhausted.
Can I just interject and say thank you as a lawyer for being really transparent about that element, which as a divorce coach, I try to remind my clients, you can litigate and you can stretch this out. And those that are primarily going to benefit are your lawyers, because you're just going to get stuck, do more damage to your future relationship, and spend a lot of money. And the judge doesn't even want to see you, as truth may have it.
And unfortunately, despite the fact that I may hammer on that point in conferring with potentially new clients, many people just don't get it.
Yeah.
Until they get the third or fourth bill, then they start understanding.
Yeah.
But so what happens is statistically, this is what's going on. You're not going to get your day in court. The corollary, however, is also true. You may not want to get your day in court, even if you could get your day in court. And so the question is, why is that? Well, the reason that is because people are under misconception what divorce court is like. They think it's going to be like on TV, that there's going to be a quick hour-long show, maybe 30-minute show, maybe a 10-minute segment. The court's going to quickly dissect their issues, make these wise statements or wise-ass statements, and they're going to be done. Or alternatively, they may think this judge is going to see the whole reel, the whole movie, just like watching Netflix, of my marriage, my life. Then the court's going to retire to his or her chambers, and they're going to agonize and carefully sculpture out the result that was going to do justice to them and make everything happy, and everyone will live happily ever after. False, false, false. The judges have thousands, hundreds, if not thousands of cases they have to deal with. They have less money, less assistance, less time to deal with it. They're not going to do it. And they're going to tell you there's a time, generally at some point in time, where the judge will have a pretrial conference and have clients and attorneys appear, and he or she will give what I call the talk. The talk is this, I'm going to try my best to try your case. I try cases all the time. But I warn you that the two people in this courtroom who know most about your lives are you two. And you two are best suited to try to come up with a solution that works. Because I'm going to tell you, I'm going to try my best, but I'm probably going to get it wrong. And if they're not, the judges are not telling them that, the attorney should be telling them that.
Yeah. Yeah.
Another misconception, and then this is sometimes based on emotional need, is you're probably going to have to sell the house. Many parents, particularly women, and again, I'm not trying to be misogynistic here or sexist, but there's an emotional attachment. They think the children, and to a certain extent, they are correct, children are bound to the house or the neighborhood, and they want to do everything to keep that kind of stability for their children. It's financially not worth it. There's two things going on, your immediate emotional needs versus your financial future and the financial future of your children. For many couples, the asset that has the most value is the marital home. Correct. So for the most part, if marital estates are going to be divided in half, and I'm making a generality here, of course, but let's just do that as an assumption. If we're going to divide them in half, then that's where else are you going to get your nest egg to try to start over? Whether it's to find a new place that's maybe have to downsize a little bit, or somehow convert it over into something else, whether it's temporary or permanent, another house or an apartment, or renting somewhere or moving somewhere. I mean, but you've got to be realistic about these things, and it's an emotional process. A therapist once told me long ago, and I thought it was a good piece of wisdom, was divorce is an emotional, tumultuous situation upon which the society has scaffolded artificially laws and rules. And we ignore, the law ignores the fact that there's this emotional maelstrom going on. And that's one of the emotional issues that we have to deal with. Courts and laws are become alimony. Alimony is another big issue.
Also referred to in some states as spousal support.
Spousal support.
I think is the new term. So just translating for our listeners.
Thank you. And also because I've been doing this a long time, I have a tendency to lapse into older terminology. Spousal support or alimony. Across the nation, we're becoming more formalistic. What do I mean by that? Formulas are becoming more and more in vogue, and legislatures are slowly migrating that way. Recently in Florida, we had a major change that we have somewhat of a formula, but not quite. So that might be, then maybe you have to check your state to see if that's there. But if there's any kind of discretion to the judges, I'm just telling you over my time practicing law, alimony is becoming less and less generous. The judges are becoming less and less generous with alimony. So if you're depending upon big alimony awards, unless you're in a particular case, it's not going to be there.
Yeah. And to reiterate, that is different in every state.
Absolutely.
And it can be wildly different from state to state.
But again, the more discretion the judge has, my sense overall is that's becoming smaller and smaller. Well, that doesn't mean if you're in a false state, if you commit default, then you're going to get punished for that. But Florida's a no-fault state. Many other states are no-fault states. So if there's no fault involved and there's no wasting of the marital estate by someone going out and having affairs or doing drugs or investing in Bitcoin secretly while the marriage is breaking down or during the divorce, you're probably not going to get much of a go there. So if you're depending upon alimony to cement your way to a better future permanently, don't count them. At the same time, I also tell mainly male clients, don't think you can get out of paying child support. Everyone's sort of this misunderstanding that somehow there's some magic number or some magic formula that'll happen and I can escape my responsibilities. No. Child support more than alimony is a formalistic number.
They're going to put all the numbers in and
put the numbers in, and the judges are required to make an inquiry, at least in Florida, is child support pursuant to the child support guideline statute. And if you say no, then there are very few exceptions that you can fit into that if you haven't pled, you may not be able to utilize anyways. And even if you utilize them, the judge may not approve them. So
Mm.
you got to be careful with that. So be realistic about that. Be honest with your attorney. You know, everyone has what I call the skeletons in the closet.
Yes.
Believe me, there's nothing you can tell me that I have not heard. It is going to be confidential, even if you tell me anyway. So I'm not going home and tell my wife, or I'm going to the bar and tell my friends, oh, you don't believe what I heard today. Attorneys don't do that. But we've got to know that, because I can tell you, 99% chance, if you don't tell me, you know when I'm going to hear about it? When you're on the witness stand, being cross-examined.
And that's
in a
going to be the
deposition.
worst time to hear it.
Well, of course, because I am structuring your case based upon your goals and based upon the information you provide to me that I can substantiate. So if something comes out of left field that, you know, you're, you know, a cross-dresser down at the community bar, trans bar, and no one knows about it, that may not be a big deal, but it could have an impact on child issues, could have an impact on income issues, could have an impact about everything else. But it's a very embarrassing way to do it. And if you lied about it on direct, and then it comes up in cross, then it may hurt your credibility with the judge.
Right.
So,
right. It's not the thing that you are or the thing that you've done. It's the absence of transparency that erodes the credibility. And I try to remind my clients, the more I know, the more helpful I can be. So lay it all out there.
And then the corollary to that, the things that you don't tell me are the ones that are going to come back and bite us in the butt.
Yeah. Yeah.
Now, probably one of the most important things people don't do, and they should be doing in their divorce case, no matter how they proceed, is prioritize your goals. What does that mean? That means start sitting down and figuring out what's the most important thing to me. Because I'll have gentlemen come in and say, I want 50-50 timeshare. And I'll say, well, you're on the road traveling all the time. How's that going to be even possible? Aren't you telling me you want to have a good relationship with your children and have time when you're available to do that? So let's identify what's the most important thing. That may not be the most important thing. Maybe saving the family business is the most important thing, but they're talking about kids to me because they think that's the right thing to talk about. Well, it's not in their pantheon. It doesn't do me any good to try to be arguing for the kids, time with children that he's not going to be able to exercise, when saving the family business or making sure he ends up with ownership of the family business, by whether he's bought out or however you do it, is the most important thing to him. So again, it's hard because everyone comes in and they say, well, I want to be treated fairly. Well, fairly doesn't tell me what that means, because what's fair to you is not what's fair to your spouse, what's not fair to the judge.
Right.
Or I want to do what's right? I want what comes to me. Again, those are abstract things. So I try to tell my clients, it's got to be identifiable, it's got to be measurable to a certain extent, and there's got to be some time factor set on. For instance, to say I want 50-50 of all the assets, or the value of all the assets, not unreasonable request. It's tangible, I can identify it, I can understand what it means. And there's a time set to it, because by the time this case is over, that's when I want. So that's one thing. And also, let's be realistic about our goals. If you would say, I want to relocate to Bozeman, Montana from West Palm Beach, Florida. Well, what's your reason for doing so? Oh, well, because I heard it's pretty good up there and I might be able to get a job. That's not enough reason, and that doesn't justify moving to a judge. And it certainly doesn't preserve whatever relationship the other spouse has had with them. So, but if that's your goal, let me know what it is so I can tell you, it's achievable.
Correct. And I think this question that through the good divorce process we say is, what is it that you want? And I'm not talking about assets. Like, what do you want the family to look like? Do you want to go to parent-teacher conferences together? Do you want to sit together in the stands at the choir concert and the basketball games? Do you want to have a wedding for your child 10 years from now where they're not having to mediate their parents' bad divorce 10 years later? And that really then puts the story into the decision making in the here and now. And you're right. We just start land grabbing around the money and the tangible things and the visible, when there's this whole invisible story that also encompasses those decisions. So getting people
And
clear on their wants.
And then look at it just on the monetary fashion. If I'm the attorney and I know there's a limited budget to every divorce, I don't care whether you're from Palm Beach, Florida, or Bozeman, Montana.
Yeah.
There's not all the money in the world to be spent. So if you're telling me what's the most important thing in the world to you, then I can devote your limited budget to achieving those things or building a plan to get that. At the same time, it helps me manage you. What do I mean by that? I don't want to say that I'm sort of there with a whip or something managing you, but you inevitably during the course of the divorce, I'm going to get a call from you, and your spouse will have done something, good or bad, that's going to torque you off. And when it torques you off, you're going to say, I want something done. I want you to put your heel on their neck and squeeze. I want the judge to, send them to East Siberia to the gulag. But
and it will happen.
It will happen. And if it's the first goal, then I can say, okay, well, let's talk about what kind of motion we can bring and what we can do about it. But if it's goal number 7, I can say, listen, Mrs. Jones or Mr. Smith, it's number 7. Maybe we ought to send a nasty letter and then save the money from doing a motion that's not going to really do much for you in the long run, entertaining the goals you really want. Finally, it's a way for you to be able to determine how well have I done. You won't believe how many times people have come to me after the divorce is over and not sure what's going on, not happy with the results. And I said, well, how'd you do in terms of your goals? Well, they had no goals. And then I asked, well, what was the game plan to get to goals? They have no game plan, which comes down to the next point. Make sure that you take the time to sit down and understand what's the game plan to get what I want.
Mm-hmm.
And what if it's going to take depositions, or is it going to take experts to come in, that type of thing, so I can understand the expense and I can understand the why. And then my classic question after that is, what's the plan B? If plan A doesn't work, what's plan B? Because you're litigating now. Maybe you'll end up settling this case, but if you see you understand what the plan is, then you understand what's costing the money, and you understand what your attorney's doing or not doing. So many times I see cases where they're going to start off, okay, we got mandatory financial documents that come to us. Then we're going to send out this standard request for production of documents, standard interrogatories, but you're not getting down to sort of scalpel, surgically putting together the discovery request that will get you the information you need to get you in position where you want to be to win the case if you have to litigate it, but also be able to prevail in mediation. Mediation. There are closers and there are non-closers. And now I'm talking about people who are litigating divorce, not people who are trying to do it the civilized fashion that you provide, pathway. But I'm talking about people, we're down and dirty, we're mediating because if we don't get this settled, we're going to trial.
Yeah.
Mediators, there are closers and non-closers. The closers are the ones that can get you a result that you can live with. Now, what do I mean by that? You ask most people, how'd you do? Well, I say, how you do is based on this. There's a result that you can live with, which means there'll be some provisions in the final judgment or mediation clauses that say that you like, some you don't really care for, and some you're But overall, you can live with the results. In other words, you can be comfortable financially. You can have the relationship you want with your kids. You may not, there may be a couple of things you didn't get that you wanted to get, but that they were down on your list of priorities. So again, it's not vanquishing the other side, it's getting an agreement that you can live with, which is basically what will happen in most successful mediation. So those are some of the basic things. And people also come to me all the time. Here's a common question. They're hiding money. There's something in Bimini or out in Butte somewhere, they've got a secret account, and he's shelling away money, or he's got I had a case once where someone was putting gold coins up in the attic of the house. Well, I said, if we can prove it, that's well and good. That's how we try to prove it. But if we no, we can't. We have crypto coins. He's in doing crypto. Well, I find out the crypto he's worth $45. Said, we have any other quick evidence? So for the most part, unless someone's dealing with large sums of money in their marital estate, people don't have the assets to do the sophisticated hiding of assets that's needed to be done to escape. thing.
Yeah.
Most cases, if they've got any kind of concern, they may have some money attached to it. Getting a forensic accountant that has some fraud detection ability and experience is probably the best thing to do. So
Right.
don't come to, but don't come running to me and saying he's got $1 million somewhere and you don't have any proof of that. You just know it in the bottom of your heart.
And it's my understanding that in a number of states, if something has been hidden, it wasn't presented in the discoverable process, that there is a, shadow period post-divorce decree in the settlement that if it's discovered, then the person who is hiding it relinquishes 100% of it to the other spouse.
That has to be, well, for instance, in Florida, that would have to be part of your judgment. There is a provision that says that if you're if you committed some kind of substantial fraud during the course of the divorce, you can bring it back and have the divorce sort of X'd out and start over again. That's up to that's fraud up to for a year. After that, if there's fraud in the financial affidavit that was filed, in other words, you had $100,000 of gold bullion stashed in the Bahamas, and that comes up later. That's enough to come back and say you filed a fraudulent financial affidavit. We get to go back and deal with that issue.
Yeah.
But each state has a different process to that. Again, and you can have in your settlement agreement or request a judge to order that if it's found later, just be forfeited. But that's not one but that again depends upon case by case.
So much good advice and wisdom. We're chatting today with Charles Jamieson, certified marital and family law attorney from West Palm Beach, Florida, over 40 years. And I just want to recap in that 40 years of experience, a few of the things for clients to think about as they enter into a relationship with their attorney. One, you're probably not going to get your day in court. And for the judge to hear your story and empathize with you, and chances are you probably don't, because the two of you, if you can stay in the conversation together, that's where you have the most power and the most knowledge. Secondly, really think about that asset and the home as the largest asset and what is going to be in the financial best interest of the family. And it may not be retaining the family home. Third, spousal support, formerly known as alimony. It's becoming more and more constrictive across the country. So if you're counting on being supported by your former spouse for the eternity of life with loads of money, that may not be the case. That might be a falsification. Fourth, child support is not something that you should try to negotiate your way out of, whether you're the father or the mother or you're in a same-sex couple. Child support is there to do exactly as it is identified, is to support the children. Fifth, be honest with your attorney. It's going to come out. I had a mentor who always said, tell the truth. Everyone knows it anyway. And if they don't know it yet, eventually they will. You don't want to have any surprises if you end up in court. Prioritize your goals, that idea of what is it that I actually want as an outcome? What does it look like? And to that end, then have a game plan to reach those goals. A game plan A and a game plan B for the backup. Think about mediation as a result that you can live with. A good mediation, a good negotiation is where everyone feels like they lost a little something and they gained a little something. We're looking for the middle path. And don't hide resources and assets. And more importantly, if you're the client coming to your attorney and saying, I know they're hiding something, chances are they're not, and you might spend a lot of time and money going down that rabbit hole. Did I get it right, Charlie?
You nailed it on the head.
That's great. Well, those are your words. I wanted to make sure our listeners could capture it, so they'll come back after the break as we continue our conversation with Charles Jamieson, marital and family attorney. And we're going to talk a little bit about what has happened since same-sex marriage has become legal and just long and short-term relationships within the LGBTQ community. Stay tuned. I'm Karen McNinney, your Good Divorce Coach.
Are you thinking about getting divorced? Before you call a lawyer, call the Good Divorce Coach, Karen McNinney, a certified divorce counselor, co-parenting specialist, and mediator. Karen's signature Good Divorce experience will guide you through your divorce journey, from the day you make that difficult decision to the day the decree is signed, all for a predictable fee. The Good Divorce Coach will teach you and your partner how to get divorced and be divorced with less conflict and less debt. Visit thegooddivorcecoach.com to get in touch with Karen.
Now, back to the show with Karen.
Welcome back. I'm Karen McNenny, your Good Divorce Coach. We're chatting today all the way from West Palm Beach, Florida, chatting with board-certified marital and family lawyer Charles Jamieson, more than 40 years in practice. And before the break, he shared some wonderful nuggets of wisdom of what you should know, clients, as you head into a conversation with your lawyer. But I suspect there might be some of you listening in today that you're not quite across the divorce threshold. You might be in that messy middle, that purgatory place of, are we in? Are we out? Should we stay? Should we go? Maybe it's not bad enough. It's not good enough. Most of you listening know that place. And you're either sitting in it or you finally have busted out of it. But it's a very real kind of tormented stage of the marriage divorce journey. So, Charlie, you have some thoughts about if you are in that kind of still discernment stage, what you might consider as a formal engagement of a separation that's going to serve you well as a couple. What are some things we can think about?
Well, one of the things you can think about is a concept called controlled separation, which is really kind of a contract. Most people think of separation as an experiment about being single and transitioning from being married and being working single and getting into a post-divorce life. Controlled separation is a chance to try to save the marriage. And there are movements around the country to try to keep couples in marriage that can be. And what a controlled separation is, you'll be working with a therapist or a divorce coach, both of you individually and potentially together. You're putting together a quick contract. The contract is from 3 to 6 months. During the contract, no divorce is going to be filed until the contract is over, or unless both parties agree that that should happen. Then only after a conversation occurs about that. The second important thing is someone's got to move out of the house. So there's some kind of separation. Generally, the person who's making more money moves out. Kids stay in the house. Third, you agree upon who is talked about. What do you say? What are you going to say to whom and about what concerning this separation? Because you don't want advice coming out from other people who may be well-meaning, but they're going to only torpedo the result that you're trying to accomplish here. And also, you agree upon what's going to be said, so it's a mutual message. There's a question about what kind of family time are we spending together? In other words, if they're kids, what kind of events are we going to do? How often is that going to be? We have time sharing and visitation schedules set up. There's also a question about alone time between the parents. Where we're going to go out, how often that's going to be away from the kids. And there's no talking about the divorce. There's no talking about the process, just talking about you two. And in attempts to reconnect if there's possible. And then also quickly, there's a clause about intimacy. What kind of intimacy, if any, are we going to be permitting upon the consent of the parties? Now, obviously, this works well for that kind of couple where all at once one's is absolutely convinced that there's going to be a divorce that occurs, and the other person is just walking around shell-shocked. I never knew anything was wrong. That's one way it may work. Another way it may work are couples that are what I call child-centric. They really want what's best for their kids, and there may be grounds for which their marriage can be saved. However, what's not appropriate are those couples where there's a power differential, where there's been emotional abuse, physical abuse, even sexual abuse within the relationship. A relationship where one spouse lying is not truthful. I'm now outlining to you the classic narcissistic, sociopathic kind of individual. Those are not appropriate. But this is a way, 3 to 6 months. If you want to try to save the marriage, you can. Now, ironically, at least in Florida, divorce attorneys are ethically required to ask their clients, I think in part because we're a no-fault state, is there any way that you could possibly save this marriage? Now, sometimes I have to answer yes. Well, if I ask, have you been to therapy? Yes. Has it been successful? No. Well, this is a different type of therapy. This is a different type of passage. But it takes both couples to agree. For someone like you in your process, perfect. I mean, you're doing it already, but it's a perfect transition. Because A, you can exit out with a contract of how I'm going to be as a married couple from now on, versus, well, we're going to get a divorce. But if we're going to get divorced, we've already set up communication. We've already set up respectful in discourse. The kids are already sort of knowing things are going one way, the moment mom and dad. And it gives you the opportunity to save money, save your emotion, and save your children and your future by going through this process. If you are in what I call that, there's always that opportunity, what I call period of opportunity. You don't know how it is, but if you may be able to do something that could change your life, change your marriage, change the divorce.
Yes, and that it changed the divorce. And I wholeheartedly support what you're saying, and I've seen it in action, because couples sometimes do come to a divorce coach before they go to a lawyer. At least that's always my preference, is to start in the conversation, get emotionally regulated, get clear about what it really means. There's a movement, as you mentioned, around the country in terms of saving marriages, and this controlled separation, sometimes also referred to a new movement called discernment counseling. When you actually work with someone and that is their whole purpose, is to discern whether or not you're going to stay married or move into a divorce process. And doing this groundwork almost creates a runway for the divorce rather than leaping into the battle and getting you into a place where you're functioning from your executive function of your brain and making decisions, and you've talked through and created some empathy and compassion in the relationship before you start to unravel it. And there's always those occasions where couples do find a way to rekindle and renovate the relationship inside the marriage. And we celebrate that, right? That would be the ideal. Nobody gets married headed towards divorce. That's not the goal. However, if you find yourself on that threshold of divorce, Charlie has another wonderful recommendation as you think about what we're committing to and what we want to look at as we are in every conversation, and this idea of a mission statement. Unpack that a little more for us, Charlie, and what you
Yes,
mean.
but I'd like to preface that as follows. You're talking to a 40-year divorce attorney. And so I'm not the kind of guy that believes in kumbaya around the campfire. But I also know that this is a process that can destroy people, their lives, and their futures. And it's my obligation, and I've learned over time, not to be always the destroyer, but also to lead the pathway to a better way, if in fact my client and the opposing party are capable of doing so. So let's talk about another way to try to get people to act their best when they're at their worst. That's what I call the divorce mission statement. A divorce mission statement is not unlike a mission statement anywhere else in your life or in your business. We hear that in businesses, self-actualization coaches talk about making your own personal business mission statement. This is one for your divorce. So what is that about? It's about identifying your best core values, your best core beliefs, and how you want this process to be. And you write it as if you're in the future looking past. So you're not going to, if you want it to be a successful process, you're not going to say, every time I got to jam them, I did, I screwed them out of money. I was, I played around with the kids. I had other people introduce the kids. You don't want to ever write so because no one wants to be really that way. Yeah. So what you do something to the fact that, I want at the end of this during the process and at the end of the process, both sides are economically comfortable. In other words, no one got rich, no one got poor, but we were fair in treating each other with the fact that with our children, we wanted our children to be intact afterwards. We did not want this process to harm them. Afterwards, we want to be able to be civil, have civil engagement with one another. We don't want to sit at our children's weddings, our children's christenings, our children's graduations, and other major events in their lives like two warring camps glaring at one another across the hallway. We want to have our children, we want to be able to be together, have our children be together with us now, and we want to be able to engage with each other together afterwards. Now, sometimes that's possible, sometimes that's not. I'm not recommending that you put it in there if you don't think that's going to be there, but that's what you're going to do. I'm going to be transparent in my economic dealings in this the denouement of this marriage during this dissolution process, which means if financial documents are required, I'm going to do that. I'm going to, rather than play games with everything else. So again, you sit down, you can do it together, and then in cooperative or collaborative divorces, we do have them do, when I'm involved, I make sure that parties do it together. That's one of their assignments. But even if you're in a contested divorce, you yourself can sit down and write your own. And again, what does it do? It gives you your your lodestone to where you're going to, leads you back to the path. It's easy in divorce cases. It's an emotional process. You're in the middle of a maelstrom. You don't know what your future is going to be. And to a certain extent, you're fearful or have at least some kind of anxiety about them. And because of those kinds of emotions, you sometimes are going to veer off the path of your best behavior. You need to have something that you both can look to, or you just yourself can look to, is what I'm going to be. Because at the very least, let me tell you this. Your children are watching you like hawks. I don't care if you're 2 years old or you're 18 years old or you're an adult. They are watching you to see if you're going to act with some kind of grace and some kind of humanity with one another, because they are your parents. You are their parents, and these kids, they have two people to choose from how they're going to act as individuals in life. And you're the two most important ones in your life. So just on those factors, you should be doing to try to do something to keep you on your straight and narrow. My job is to advocate for you. My job is not to make you be your best self. I can try to get you to be there. I can try to have you identify that. But unless you're doing it in the early stages of what I call the window of opportunity, of what I call grace. In other words, people are willing to be fair, willing to be more fair than they are when they start drawing swords and knives and glares. So that's one area.
I think that is such a good practice. And this word grace, the opportunity, the window of opportunity for grace. I've heard grace defined as my ability to offer up forgiveness, particularly to someone I think is not deserving of it. And that can really become true when we're in a divorce and we see the person we fell in love with, the person that we married, the person we had children with, and we see them as the enemy. And I'm reminding you, there is still a love story wrapped up in there, listeners. You don't have to take the swords out, which is my question to you, Charlie. It's great when we're in a cooperative or collaborative process. I tend to work with both couples from day of decision to day of decree, and you can write that shared mission statement. But what do you tell the client that's sitting in your office and they write their mission statement and they're ready to offer grace and to be compassionate and empathetic and want to do the right thing? And they're like, but my soon-to-be ex won't do any of this, so it doesn't matter. What do you say to that client?
I say, what I just said, your children, what's the most important here to you when it's all said and done? When the memory of your actions are being mulled over by your children, which one are they going to say? Were you naive or did you act with grace?
Yeah.
But the second thing I remind them is one thing we talked about earlier, which is what's the end stage of this agreement that you're reaching? Is it something that you can live with? Because there are some people who are going to be unfair, but remember, if we're talking about personality disorders on the other side, then all bets are off. My job is to draw my sword, hunker up my shield, and go to war, because that's what this is about, to protect my client. But it doesn't mean my client can't say to me at some point in time, enough's enough, Charlie. You punished them enough.
Yeah.
That's their grace. But it's difficult because we're dealing with high emotions. People do not always think straight with high emotion, which is why I try to make sure they give me the prioritization of their goals. So I can tell them, you're making me go to war for a goal 5. Let's get you protected on the kids' issues if that's more important to you. Or if you want this piece of property, if there's several pieces that you want this, we'll get this piece of property.
Great. Well, before we wrap up today, we did promise our listeners a little bit of insight around what is really a new area of law. We've got folks in the non-binary, same-sex couples, LGBT community who either have not had the opportunity for legal divorce in the past, are not choosing legal marriage, or not choosing to participate in legal marriage, but we have these long and short-term relationships that at some point they will unwind. Some of them will unwind. What are your best guideposts for those folks who might be listening today?
Well, generally speaking, with the LBGT plus communities, you're generally having, particularly if you have a long-term relationship, that's the one that's most problematic, because the ability to get married is still a relatively short-term thing. So what happens is the law is governed for divorces are governed generally by, in several issues are governed by the length of the marriage. So if you have a long-term relationship and a short-term marriage, the law is sorting out some of the rights that you may have thought you should be entitled to. For instance, if a couple gets together and they have an agreement, Jan or Joe are going to be to save, put their money away, as much money away they can for our retirement. We'll live off of Jack or Jan's income. And they do that. So what happens is then they've been together for 20 years. On year 22, they get married because they can. 5 years later, they get divorced. A 5-year marriage is generally short-term in many jurisdictions. You're not going to qualify for spousal support, whereas you'd be looking at a 25-year marriage if you're accounting for that. Well, then you got to get creative. You got to hope they're in one of the few communities. They were living in one of the few communities for the majority of the time that recognize common law marriage. Then you got to go back and try to establish that common law marriage. So you may be able to help them, but that's more the exception than the rule. So that's for the division of property. It's also for the calculation of alimony or spousal support, which is based on time. How do you remedy that? The remedy that is, if anyone's getting married in the future, write out a prenuptial agreement. Prenuptial agreement can say, we're going to divide everything from this step. It's all common. And then I recognize we had a marriage for 22 years, and alimony will be either X amount or will be calculated as there's an X number of year marriage. Children. There may be children that were born during the course of the relationship, that particularly if there are two females involved, where one female actually gave birth to the child, the other one has not, and so they're not legally bound to that child. So we advise, if the couple comes to us early in the stages before divorce comes, that there's what we call a second parent adoption occurs. That second parent legally adopts the child, so they have rights to that. Now, the Supreme Court case that gave rights for LGBTQ plus people to have marriage is now, each year goes by, gets longer and longer. So we're seeing fewer of those kinds of problems, but they still are out there and they still exist. So my advice to anyone who's getting married, no matter what your persuasion is sexually, is go see an attorney and talk about either a prenuptial contract if you're getting married, or a cohabitation agreement if you're going to live together and not get married. Now, that cohabitation agreement will not take care of all your issues, but will take care of at least some of them. So
that's very, very useful information. And I know that the bucket of wisdom is deep, and we may have to have you back on the Good Divorce Show in order to squeeze a little more, Charlie. But as we wrap up today's episode, is there anything that you would just grab hold of that you know now in your 40 years of supporting families through divorce that you wish you had known earlier from the perspective of a lawyer?
That it's better to be effective than it is to be right.
Oh, that's great. Sometimes I hear that said, do you want to be right, or do you want to make it right?
Or do you want to be right, or do you want to be happy?
Yeah. And sometimes the wounds and the hurt and the pain and the bitterness and resentments of the marriage, they're not gonna you don't have to carry them into your divorce. You're starting a new relationship with your co-parent. So you have a choice, listeners, of what you want to leave behind and what you want to keep toting around in your baggage. And you can keep loading it up, but it's probably not going to serve you, and it certainly isn't going to serve your children to be living with angry, resentful parents.
which is certainly why individuals like you as divorce coaches or therapists are still an integral part and have an important part to play in any divorce case, even after the divorce has commenced.
Well, thank you so much for that vote of confidence and support. We've been chatting today with Charles Jamieson, board certified marital and family law attorney based in West Palm Beach, Florida, but serving families around the country and has been doing so for 40 years. Thank you so much for being on the Good Divorce Show, Charlie.
My pleasure, and look forward to coming back soon.
Yes, I think that will happen. And to all of our listeners today, I say it every week and I'm going to say it again. Please remember, everything will be okay in the end. And if it's not okay, it is not the end.
Thanks for listening. Do you have questions or thoughts about this week's episode? Let us know by following the Good Divorce Coach on Facebook and Instagram at Good Divorce Coach, and leave a comment. And be sure to tune in every Monday at 10 a.m. Pacific or listen anytime wherever you get your podcasts.